Julie McFarlane is a professor at the University of Windsor, Faculty of Law, and the Kroc Institute for International Peace Studies at the University of Notre Dame. She's the author of the best-selling The New Lawyer, How Settlement is Transforming the Practice of Law, published in 2008, and in 2012 published Islamic Divorce in North America. Her most recent work is a national Canadian research project, collecting the stories and experiences of self-represented litigants.
Thank you very much, Nancy. Well, when Peter Salem called me and asked me if I would help to convene a panel on something called the Family Court of the Future, and as someone who is accustomed to Peter's impossible requests over the years, even I, with that experience, felt like this might be a somewhat overwhelming task. And in the weeks that followed, myself and my panel members exchanged in discussion and on the email our various ideas of what the challenges of the future of the family court would be. We reached a point when we realized that we would probably need about a month's worth of sessions to be able to describe all of those to you. Here are some of the things that we came up with. And these are just the themes. Believe me, there were pages and pages and pages of challenges that we came up with when we thought about the future. This is the future, and it's not good.
We need more funding.
Resources and funding for court-based and pro bono programs. And I can't tell you, of course, how often that particular challenge came up in so many different iterations. The changing nature of family clients, the different expectations that people who are used to access to information on the internet and who are growing up in an age where there is far less deference to professionals and perhaps to courts, the different kinds of expectations that these new family clients were bringing. Changing family structures, the many and diverse ways in which people constitute families today, and all of the challenges that they bring for a system that tries to help them with their conflicts. The adversarial model. We've been there a few times, haven't we? Delays, expenses, and its incredible capacity to increase conflict. And finally, even the technology, which we see as having some promise and potential, also brings with it a few problems. And the impact of that. So we came up with this list and realized, as I said, that we would probably need to keep you here for about a month to discuss them. So we came up with Plan B. Plan B is that we decided that for each of us, the phenomenon of the very large and growing number of self-represented litigants in the family court was representative in so many ways of all of these challenges. It's representative of the challenges of changing family client expectations, of the problems with the adversarial system, of the uses and some of the pitfalls of using technology, and of course, it's extremely representative of the problem of resources and the fact that we do not have enough resources to assist people who are trying to find their way through the system without an agent. We also talked about the fact that self-represented litigants impact every single one of us in our different professional capacities. And everybody, I'm certain, in this room who works with families in conflict sees this and has a response to it which is important and changing the way that you do your work. We've had a couple of sessions, I know already, in this conference that have looked at the issue through the lens of particular perspectives and particular professionals. So today, what we're going to do is to focus our remarks on the self-represented litigant phenomenon from the perspective of the different people on this panel, because we believe that that will give you a very good overview of some of the issues that we see out there. And once we have each had a chance to speak, myself as a researcher, Andy as a law professor and practitioner, Betty from court services perspective, Linda from court services perspective, Betty from the perspective of a pro bono organization, and finally Paul from a judicial former judge perspective. We're then going to open this up to questions, and we expect and hope for a lively discussion. So that's how we're going to use the time, and I hope that you will forgive us for our executive decision about what exactly we would focus on in terms of the future, because we think that self-represented litigants are here to stay. We will have many different views on what can be done about that, but that they impact each one of us, and they are also each one of our clients. This is a phenomenon that goes across demographics, and we are seeing increasingly in all parts of the social system. So that's the plan. So the task I set myself was to enter the world, and it really is a world, of self-represented litigants. We were basically knocked over by a tsunami wave of people. And in the end, I did interviews with 259 self-represented litigants. They're approximately an hour long each. They include open-ended questions primarily about their experience, walking through what happened to them, and some very specific demographics as well. I also interviewed 107 court services and court service providers in the courthouses to get their perspective on what they saw happening. These are folks that we often don't include in research either. People who are not paid very much money, who aren't very well trained, but they are the front lines of dealing with the self-represented litigants, and I wanted to know what they had to say. What they show is that although the majority of people who represent themselves are low income, 40% of my sample had an income of under $30,000 a year, there is also a significant group of higher income earners amongst these folks. 18% of my sample earned more than $75,000 a year. In addition, 50% of them had a university education. And what's interesting about this is how often those folks talked about how difficult they found this and how much more impossibly difficult they would have found it had they not had the benefit of this education. So people often went in with a certain amount of confidence because of that, only to find themselves in very deep water quite quickly. Perhaps one of the most interesting things that I discovered was that over half the sample, 53%, had a lawyer previously. And I wasn't expecting this. So when we look at our data, which is usually collected by the courts at the time of filing to tell us how many people are there without counsel, in fact, that data changes because people then lose counsel because they cannot afford to continue to retain them. I also have data on how much money people spent on lawyers before they reached the conclusion that they could no longer borrow any more money from their parents, that they could no longer go into debt to pay for them, and were forced to give up. And it's pretty horrifying. People spent a lot of money, but caught in a system in which they were not finding resolution. For whatever reasons, they were not able to go on hiring counsel. 86% of my sample sought legal advice. And I think that's a really important number because it shows us that people who are representing themselves are not necessarily, as I think has often been the stereotype, lawyer haters. They are people who want legal advice, they want help, but they can't necessarily afford to pay it. And they are also, in some cases, people who have already paid for that and feel disillusioned that they haven't yet reached a resolution in their matter. I also asked a question at the beginning of every interview, which was about people's predispositions. In other words, before they had this matter, what was their experience with using a lawyer? Did they have a negative attitude coming in? Very interestingly, there is no significant correlation between the people who told me they had a bad experience in a previous matter and those who wound up feeling negative about lawyers this time. In other words, their negativity arose from this particular experience. That's very clear. The overriding reason that people told me they were representing themselves was financial. Now, there are many other reasons mixed in there, because once you get to the point that you are doing this on your own, a certain amount of desperation, I think, often sets in. People talked about their negative experiences with their lawyers, if they'd had them, and there's a lot of data in the report about that as well, if you're interested. And they also talked about, feeling that they must be able to do this themselves. Surely they could find their way through this system. There's all this information out there on the internet. It must be possible for them to be able to do it. But overwhelmingly, as we went through these interviews, and bear in mind that people don't necessarily want to say right away, I don't have a lawyer because I don't have the money. People feel ashamed about saying that. It was clear that in virtually every case, money was one or the most overriding factor. So just to give you a couple of choice quotes on this. I have no choice It's not that I think that I can do this better than a lawyer. I just don't have $350 an hour to pay a lawyer. And then another woman talking about her experience of conducting her own trial. I remember thinking, do they think that I'm enjoying this? I'm doing this because I have no choice. And I think these are very important pieces to put into our narrative about self-represented litigants, that we have historically seen them as people who are out there thwarting the system, causing trouble, being troublemakers, and that might need to be refined now. So there are many other stories in my report which detail this, and if you want to look at the report, it's available at the study website, which is very simply representing-yourself.com. You'll find the report and also the executive summary and a whole bunch of different media stories that have run in Canada about the study. There were some people, but there were many fewer people, who nominated a judge who was kind to them or a lawyer on the opposite side. I have to tell you, if you want to go and look at the report, the stories about people's experiences in the courtroom during hearings with both the judge and the opposing counsel, because in 75% of my cases there was counsel on the other side, are absolutely horrifying. And, you know, I'm not presenting these to you as facts because this is qualitative research, but I think that if you read those stories, you'll realize that we have a very serious problem of a crisis of confidence in a justice system, that so many people seem to have so many very bad experiences.
So let me, with some exaggeration, summarize the key points I thought Julie's report makes about the practice of family law. Most SRLs want legal representation but can't afford it. A significant portion, not everybody, a significant portion of SRLs were previously represented by counsel and felt they wasted their money. Essentially they got nowhere. They spent $50,000 and made no progress. They had great difficulty in obtaining unbundled legal representation after they became SRLs, getting help with a motion or a settlement agreement or something like that. This one really troubles me. Significant numbers of judges and lawyers undermined their commitment to mediation as a settlement process. Not everyone, but significant numbers. Many SRLs, as Julie just said, found the other side's lawyer condescending and rude. Now, Julie does not have any real lawyer success stories in her data. You know, a few where lawyers kind of give good advice and move the process along and promote settlement. They do exist. The picture overall is of SRLs alienated and disaffected from the legal system. That's very troubling for people who are committed to a rule of law. Unfortunately, my experience with the family law bar is they tend to blame the client for those sorts of problems, and it is certainly true that there are SRLs who are paranoid, marginal personalities, angry, okay, but these are not them. These are folks. So what do these findings suggest to me? Well, first, we simply can't operate on the assumption that the adversary system makes, that everyone will have a lawyer and can, because of the legal advice, work through a complicated procedural system. We also have a major market failure in the delivery of legal services. Those of you from the United States know that we have a crisis in legal education. Young lawyers can't find jobs. We have vast numbers of unrepresented people and vast numbers of young and underemployed or underemployed lawyers. That's a market failure in economists' terms. Something is very wrong here. Okay. A personal aside, okay. I have been listening for 30-plus years in this business to, here's the solution to the problem, more pro bono representation. The bar makes substantial contributions. It's not going to do it. Okay, this is simply too big an issue. More legal aid budgets. Good luck with that with the Republicans in Congress. And in fact, legal aid budgets are down. Then we have a Commission on Access to Justice in New York. They calculated that a really poor person, even below your poverty line, has a 1 in 10 chance of getting represented in a family law dispute. They triage. They basically do serious domestic violence and child abduction. They don't do these sorts of divorces. Okay, so what have we got? We have a crisis of access to justice. We have a crisis of adversarial dispute resolution. And one of the things Julie did not mention, okay, and so we have a crisis for children. The more the children are, the more the parents are caught in a destabilizing, conflict-ridden environment, the worse for their children and the more their children's relationships deteriorate. Now, I'm going to say some stuff that's really controversial for the lawyers involved. Okay, the first thing, what can we do? Transparency. If you look at court websites I had my first-year law students try to fill out the uncontested divorce forms in New York. They couldn't do it. They couldn't do it. What's going on here? Okay, now there are some states that are better, but that's a disaster. If you saw yesterday's technology from Sesame Street, how good it was, why can't we use that kind of technology to harness how do you get a divorce and how do you reach a parenting plan, and here's the good ways and here's the bad ways, okay? That's not expensive, and it would be, and you know, here's the approximate time limits so that that information is available to everybody. We need to create new models for delivery of legal services. Where's Woody? The word unbundling needs to stop being a dirty word. It basically, while the bar has not opposed unbundling, they haven't promoted it either. We need to experiment with specially trained paralegals, nurse practitioners. It is not at all clear to me that you need 3 years of law school to do a lot of this. I'm not saying, which means, of course, that we need to talk about the definition of the practice of law, right? The way it works now is, the difference is the court services folks can give legal information and they can't give legal advice. If anybody understands that distinction, I will give you tenure at Hofstra Law School. Okay? I have studied that definition. No one has a clue. So the people who are most liked by SRLs, okay, are almost disempowered from helping them when they need the most help. And that's done to preserve the legal monopoly, which has failed. Okay. We need to reform legal education. Okay. And on that, we actually have a pretty good idea of what to do. We have the Family Law Education Reform Project. We have the broader report of the Carnegie Foundation on the future of the profession. We basically need to educate lawyers to be decent people and empathetic and manage people in crisis. And okay, so start laughing now. There are things we can do. Doctors have been better educated in these areas. It's not impossible. There's groups of family law professors who've tried very hard to do that. Are there signs of hope? Yes. Let me give you a couple. Peter mentioned I was consulting with the Institute for the Advancement of the American Legal System on the Honoring Families Initiative. ILES is developing with the University of Denver an interdisciplinary clinic, a center for divorcing and separating parents, which will train law students, social work students, psychology students, and financial planners together to divert parents from the court system, give them the planning tools that they need, only offer mediation, not representation, training the young professionals together, and also research and development for best practices so that ultimately more of these centers can offer them, which leads to a broader point. We have thought of this problem as a court problem. Okay, it is not a court problem. It is a community problem. It is a national problem, and it is a political problem. Okay? And if we think of this as only a court problem and don't invest in our communities and getting others to help us, business leaders, okay, who don't want their workers out there wasting time in a court system and losing their mental and physical health while they're going through the stress of divorce and separation, we need to reach out and work with others. You'll hear about Bill Howe and Paul talking about the simplified trial for pro se litigants. The message, though, I want to give you is we need to reach out as a community and create a group of stakeholders and have a broader dialogue about this subject. Right now, our family courts And it's not just in divorce and separation, but our family courts are being run with Band-Aids. There is a financial crisis. We can talk about child protection, abuse and neglect. This is a crisis. In the time of crisis, you reach out to other people, you work with them, and you establish an agenda for change. Maybe we need a national meeting on the direction of the Pound Conference, which helped launch ADR. We certainly need to join the National Children's Movement. The National Children's that Jim Speyer talked about yesterday. My view is that an effective family justice system is in the best interests of children and a major plank in the National Children's Movement. And we need to send that message out, and we need to reach out and work with other people.
Andy talked about unbundling, which I think we all recognize, and I know Woody is here, is an idea that has been around a long time and made very, very small amounts of progress in both the U.S. and Canada. So my question, which we have been talking about in the last few weeks in Canada since my report came out, is how do we incentivize people at the bar to do unbundled legal services when, as a lawyer told me 2 weeks ago, I have plenty of clients lining up who are going to give me a traditional retainer and pay me on an hourly rate?
I think we need to engage in a dialogue about how important that is and how many underemployed lawyers there are. That is a statement, I would say, for the 1% or the 2% of people. I don't think again, please don't yell at me, lawyers, okay? But the organized family law bar has not addressed this issue. They have not addressed it systematically. I do a lot of work with the American Bar Association. There are other groups of lawyers that recognize there is a crisis in access to justice. Business lawyers, big commercial lawyers, they recognize it, and they're trying to do something about it. I have not seen that kind of response from the organized family law bar. They are more concerned, honestly, with dealing with the high ends of the adversarial system. I think someone needs to call that bar to account, and I think we're the people to do it here, honestly.
Andy, I want to say that I agree with you in when you said it's not a court problem. I would say this way, it is not solely a court problem, because it is a court problem.
Linda's too nice to say this. That distinction is the fundamental distinction about the practice of law. What is and isn't the practice of law? The people who define what the practice of law is in American society is the bar. They come after you for unauthorized practice of law if you give legal advice, and it is that distinction is what saves you from unauthorized practice of law. It is in the bars. That distinction enabled self-help centers to get a foothold. If we didn't make that distinction, the bar was against all self-help centers on the theory that those people should get lawyers. The distinction, when you try to really analyze it, is impossible. I organized a parent education program, and you would say, here's the custody process, here's parent programs that are good for you. What about my kid? Sorry, can't help you. Legal advice. So drafting agreements, legal advice as opposed to legal information. Okay? What do these folks need? Agreements. There's no lawyer. So, I mean, but what you've seen is the process. See, there's questions about system change. The system is the legal system. Okay? And what these things are inroads into the legal system. The self-help folks, the self-rep folks present a fundamental challenge to the way that system is functioning. Okay? And the old distinction between information and advice is a product of trying to get a foothold in a system where people are supposed to be represented. The unauthorized practice of law has some benefits. I'm not saying it should be abolished. It is designed, no, I don't have that, but it is designed to protect the public from charlatans. It protects the people from false representations about what the legal process can do, unqualified people making advice. It is not an unmitigated bad. The way, however, this has been defined is confusing and difficult and prevents people who don't have lawyers or can't afford lawyers from getting help?
In some cases, self-represented litigants get ordered to pay the other side's legal costs. Are judges doing this to discourage litigation, and is this an example of judicial bias against self-represented litigants? And a second question, which I put in the same pile, how can we help our communities to treat family court litigants at least as well as we treat criminal defendants with resources?
The first question had to do with whether judges were somehow biased against self-represented litigants. And I think there is an education and training component to this in which we have not spent enough time dealing with training our judges to understand that you shouldn't be thinking about self-represented litigants in some other capacity than just as a litigant before the bar, the bench. With regard to the second part of the question, I would say that what really is at stake here, we're not going to fund. There isn't going to be money to fund more legal aid services, to provide more pro bono. The way we need to think about this problem is here are the unmet legal needs, and here are all of these underemployed and unemployed lawyers. And we need to create the economic model that matches those legal needs with the legal talent that's there. And one of the things that we, for example, with this informal domestic relations dispute trial that I was talking about, one of the underlying things here is that by speeding this up, by accelerating it, and by shortening the processes, we're hoping to attract people to be able to hire lawyers because the fees and the costs are much less. So if you look at the model, and that's what we have to do, we have to think about it as an economic model, a market model, and figure out how to match those things. Law schools need to start thinking about doing things like that. For example, the University of Arizona, the law school there they have a law firm now in the law school that's reaching out and representing people. These are the kind of models. Now, if we can just get the ABA to have an original idea, which they haven't had in the last 55 years, we might be able to change. We might be able to change legal education in a way that meets the demand side of the economic equation.
I would love to see the equivalent of Teach for America for lawyers, for young lawyers. Okay. We have built an economic. Paul's point about the economics of legal education. At this moment in time in the United States, legal education is going through a period of great change. Some would call it a crisis. Class sizes are being cut. The future of legal education is to educate smaller numbers of people, hopefully better. The model is still they're going to go into corporate practice when they graduate, and they can pay off those loans that way. And that funds faculty that do some very, very, very good things, and it funds faculty who do other things. That's a separate conversation to have, okay? In terms of the economics of legal practice, there's a book called The End of Lawyers, ? Written by, Susskind. It's about the influence of technology and computerization on legal practice and the movement from what he calls customized or bespoke modeling to allowing allowing information to be available universally through computers and all steps in between. That's the future. That should reduce the costs of legal education. It's been one of the main factors in driving down the numbers of legal jobs that are available. The second thing is Julie's book, The New Lawyer. Okay? There are roles for new lawyers, and there are roles for the matrimonial bar. They just need to start wanting to play them and figure out how to make some money from them. And it's called collaborative law, which the American Bar Association rejected. Okay? I was there since I wrote the Uniform Collaborative Law Act, and was, I said, okay, great idea, folks. There are roles. There are ways, and one of my signs of hope, which we haven't talked about, is my law students are adaptable, and they get the idea and want to be counselors more than they want to be litigators, most of them. And that, I think, will be a major trend in the future. The person who can figure out how to efficiently represent the SRLs will make a lot of money.
I was told when we started our panel discussions not to talk about law schools, but I do think law schools are a terrible problem, and the model there is absolutely not public service, absolutely, positively not. Those kids are in the minority.
Partway through my research, I realized that unless I could find a way for self-represented litigants to explain their world to people in the justice system in a way that they could hear it and understand, and unless they could hear what the justice system folks faced as the challenges that they had in dealing with self-represented litigants, this would just be a piece of research that people would put on the shelf and say, that's very nice. So 2.5 weeks ago, as a result of 6 months of planning, we held a Opening the Dialogue event in Windsor, Ontario, which invited 5 self-represented litigants from each of my 3 participating provinces, 15 of them, judges, including a Supreme Court of Canada judge, including a representative of the Chief Justice of each of the 3 provinces, the directors of legal aid for those 3 provinces, the CEOs of the Bar Association for each of those 3 provinces, and people very high up in the justice ministries, court service managers. We had a total of 60 people. It was invitation only. It was a stakeholder forum. It was not a conference. And it was facilitated by my partner, Bernie Mayer. It was an extraordinary event. I can direct you to the report and my blog on it if you want to read more about it. It was an incredibly moving, and in some cases people described it as transformative experience, to see judges and lawyers sitting down with self-represented litigants and actually talking to them about what they had experienced, hearing the impact of the process on them, and those self-represented litigants realizing that there are good folks out there in the justice system. This, I think, is a model that could be duplicated all over. And from that experience came, I'm just underwater now with proposals and initiatives from the justice system folks who attended that they want to take forward as a result. And I just want to end by reading you something from an email I received from one of the people who attended as a self-represented litigant, because, as I said, we brought 5 from each of the provinces. And this woman came from Vancouver to attend. She writes me, "From the moment I stepped off the plane in Windsor until I left several days later, I encountered an experience which I now consider to be the exact opposite of my interaction with the legal system. The chaos was replaced with dignity, indignity with respect, and cruelty with kindness. It has given me a desire to engage in advocacy in any way I can to facilitate change." So I'm going to end on that note.